Okay, hello, welcome. Thank you for joining us. We're really excited you're here. We're really looking forward to the presentation today. This is part 4 of a 4-part webinar series around best practices with e-bikes. And in this presentation, we have Erika Jones joining us. She is an expert an expert and respected advisor and litigator who's really up to speed with matters involving motor vehicle safety and consumer product safety. You'll have to forgive me, my voice is going today, so I'm stumbling finding my voice here. So I think what I'll do is I'll let Rochelle take the intro from here, just because I've got something in the throat. Rochelle, you want to save the day here and help us out?
Thank you for joining us, the National Bicycle Dealers Association. As Heather mentioned, this is our final part in our 4-part series on e-bikes and retailer best practices. We are really thrilled to have Erika Jones here with us to talk about retailer risks and concerns. And I think with that, we can just go over to Erika. Thanks for being with us today.
Thank you, Rochelle and Heather, and welcome to everyone. It's a great turnout, and we're very excited to see so much interest in this topic. We're going to focus on the 2 regulatory agencies of primary interest here is the National Highway Traffic Safety Administration and the Consumer Product Safety Commission. They have separate ways of regulating, and the products fall into the 2 agency jurisdictions with a fairly bright line, but that line has been getting blurry lately in the market. So it's a timely discussion to talk about from the perspective of the retailer. How do you know if the product that you are selling is safe and compliant, and which agency regulates it? So we'll start with bicycles, and I think everybody is familiar with conventional bicycles are regulated by the U.S. Consumer Product Safety Commission and have been for nearly 50 years. The regulation citation is in Volume 16 of the Code of Federal Regulations, and it encompasses Part 1512. All bicycles that are offered for sale in the United States must meet this standard and must be certified by the manufacturer to meet the standard. And that's true whether it's built overseas or built in the US. Once they are imported here and offered for sale, they must meet this standard. If it's a children's bike, it must be certified by an independent CPSC approved laboratory. There's a process for which labs go through to get CPSC approval, and they're listed on the CPSC website. Sometimes a lab will apply for just a portion of the standard, for example, just the brake system or just another part of the standard, and that's permitted by CPSC. It will be noted on the website if it is a partial standard approval. Otherwise, if they're listed, you can assume that they are authorized to test and confirm compliance with all of Part 1512. Adult bicycles do not have to be certified by an independent lab, but they must be certified by their manufacturer as compliant with Part 1512. A conventional, by that I mean not powered in any way, conventional bicycle is a 2-wheeled vehicle having a rear drive wheel that is solely human powered. And the word solely is important here. It means the conventional bicycle does not have a battery, and it does not have any other propulsion means other than the human powered, which is the pedaling that a human would do. Under the CPSC rules, if a bicycle is sold disassembled or partially assembled, then the requirements of Part 1512 have to be met after either the consumer assembles it or you, the retailer, assemble it in accordance with the manufacturer's instructions. So they have to write them clearly enough and completely enough to ensure that the assembled bike is 1512 compliant. Once it's out in the marketplace, CPSC can obtain and supervise recalls. We'll talk a little bit more about that later. But the typical issues on bicycles that have led to recent recalls might be pedal separation, down tube cracking, or a fender or some other component interfering with a wheel, all of these create risks of crashes and associated injuries. So there can be safety defects that arise in bicycles that need to be addressed with a recall, even separate and apart from compliance with Part 1512. But the upfront requirement for new bicycles is that they do have to meet 1512 to be sold lawfully in the United States. Now let's turn to the relatively newer sector within the bicycle market of electric bicycles. And the electric bicycle is defined as a 2- or 3-wheeled vehicle, so it can be a tricycle, with fully operable pedals and an electric motor of less than 750 watts, which the definition equates to 1 horsepower, whose maximum speed on a paved level surface, when powered solely by that motor, while ridden by an operator who weighs 170 pounds, is less than 20 miles per hour. The reason to specify the weight of the operator is just to ensure that there is a standard test procedure for evaluating the speed. You have a heavier operator, it might go slower. If you have a lighter operator, it might go faster. But for regulatory purposes, the agency needs a bright line test procedure, and this is what it is. So it's a level surface, paved, operator weighs 170 pounds, and then the measurement of speed occurs. And if it can go faster than, if it can go 20 or faster with solely by the motor, it's no longer an electric bicycle. It's no longer eligible for that status. And the implications of that are going to be clear on the next slide. The bicycle motor can continue to provide support at 20 and faster as long as the operator is pedaling. That sometimes it's called pedal support or boost. There are a number of different words that I've heard associated with the fact that the power continues above 20 miles per hour, but it must cut out when the operator stops pedaling. The bicycle manufacturing industry has classified bikes into 3 classes, 1, 2, and 3. And 3 is the one, class 3 is the one that can go up to 28 miles per hour with pedal assist, that is with the pedaling continuing to operate. This is not ratified by the government, I should say it's not ratified by the Consumer Product Safety Commission, but it is ratified now in the infrastructure law that the president signed in November. So about 8 months ago, the infrastructure bill contained a provision. It's pertaining to the use of bikes in national parks and on public lands. It doesn't go directly to the Consumer Product Safety Commission regulation, but it does ratify the 3 classes in that part of federal law, which I think the manufacturing sector was happy to see that happen. At this point, there is no industry classification to go faster than 28 miles per hour under pedal assist. And that doesn't mean anything in terms of regulation, because as I mentioned, CPSC hasn't even recognized the 3 classes. They haven't disowned them either. They just have been silent about the fact that the industry uses these 3 classifications. They rely on the language at the top of the slide about the maximum speed when powered solely by a motor is less than 20. And that's all that CPSC focuses on right now. If a motorized vehicle can operate 20 or faster without pedal assist, it is no longer an electric bicycle, and it is no longer under the jurisdiction of the CPSC. It becomes a motorcycle that is subject to NHTSA jurisdiction. NHTSA is part of the Department of Transportation and has a definition of motorcycle that has been on the books for over 50 years. It is a motor vehicle with motive power, having a seat or saddle for the use of the rider, and designed to travel on not more than 3 wheels in contact with the ground. There's no speed limit in that definition. And in fact, prior to 2002, NHTSA asserted jurisdiction over all electric bicycles through this definition. They said it has motive power, that's the battery. It has a seat or saddle for the use of the rider, and has not more than 3 wheels in contact with the ground. So we are claiming it to be a motorcycle. Congress got involved and changed the regulation that we looked at just a moment ago. This definition at the top of this slide was added by Congress in 2002 in response to NHTSA's assertion of jurisdiction. The bicycle industry cannot typically meet the motorcycle requirements and therefore wanted to have that restored to CPSC jurisdiction, and Congress agreed to do that. So that's where that definition came from. It's in the Consumer Product Safety Act now, and CPSC amended Part 1512, the bicycle regulation, to add this definition into the reg. So it appears now in the regulation and in the statute. And NHTSA has not amended the motorcycle definition in its rules, but it has adopted the statutory direction from Congress, and they do not claim jurisdiction for a product that meets the electric bicycle definition. So it's now acknowledged by both agencies where the bright line is when a product stays within CPSC jurisdiction and therefore subject to Part 1512, or comes over to NHTSA's jurisdiction, and then it is subject to various standards that apply to motorcycles. So these are the two agencies we've been talking about. U.S. Consumer Product Safety Commission, their logo on the left. They regulate consumer products, including conventional bicycles, electric bicycles, and other micromobility products. NHTSA, part of the Department of Transportation, their logo is on the right. They regulate motor vehicles, including motorcycles, mopeds, motor-driven cycles. They're all considered subsets of the definition of motorcycle, and motor vehicle equipment, which would be accessories that are used with the motorcycle. For example, an add-on trunk or carrying capacity for the motorcycle would be considered motor vehicle equipment. The U.S. Consumer Product Safety Commission is an independent agency. It's not part of any department. They have three principal ways in which they regulate bicycles and other consumer products. They adopt consumer product safety standards. I've already mentioned there is one for bicycles. It's called Part 1512. And bicycle manufacturers have to certify compliance before they distribute these to you and before you can sell them to the public. CPSC has the authority to ban certain products, pardon me, by adopting a regulatory ban. For example, certain products containing lead paint are just banned and they cannot be sold. And there's a list of those contained in the Code of Federal Regulations. I think the only one of interest to this group is the lead paint ban. I think the other things are not part of what you're likely to be retailing. And the third part is a mandatory reporting of potential safety hazards, and CPSC can obtain recalls to address actual safety hazards. Retailers are subject to CPSC's reporting requirements and may be asked to do a recall of a hazardous product. You've probably seen some of the coverage in the media of CPSC's very public fight with Amazon right now, in which they are seeking to get an administrative law judge to order Amazon to do certain recalls of products that it was delivering to consumers after offering them for sale through the website. And Amazon was claiming that CPSC did not have jurisdiction over that method of distributing products to consumers, but CPSC has won the initial rounds in that litigation, and it looks like it's potentially going to be resolved with a settlement. It's a little bit too early to tell. But once a product has been recalled and public notice is given of that recall, retailers cannot sell that product any longer. So normally the manufacturer would initiate the report and the recall, the retailer would be notified, and sale would cease at that point once the manufacturer notifies the retailer. But CPSC's statute does authorize it to seek the recall directly from a retailer, and it has done so in the past, and we expect they'll continue to do so in the future. And they can obtain penalties from retailers who don't report potential defects in a timely way. The other regulator of interest is NHTSA, which most of you will not be dealing with because you don't typically sell motor vehicles or motor vehicle equipment, but you want to know where the line is, because if you're selling a product that is actually a NHTSA regulated motorcycle, you can be liable for penalties for doing so. So kind of similar to CPSC, but a little bit different. NHTSA has two primary ways of regulating motor vehicle safety. They adopt federal motor vehicle safety standards. These appear in Title 49 of the Code of Federal Regulations. They've adopted about 50 standards for different types of motor vehicles, 9 of which apply to motorcycles. And they're quite strict. They regulate headlamps, they regulate reflectors, they regulate the brakes, they regulate the brake fluid, the brake hose assemblies, the controls and displays that appear to the driver to indicate low fluid or windshield wiper, if that happens to be equipped with one, or other safety notices or warnings that need to be given to the operator of the motorcycle. So there's 9 of these standards. A typical bicycle, even an electric bicycle, won't meet any of them. So if the electric bike is in fact capable of motor power without pedaling at 20 miles an hour or over, then it's subject to these 9 standards, needs to be certified by the manufacturer to comply, and you cannot sell a non-compliant motorcycle without under the law. And if you do so, you would be risking significant penalties. And then CPSC and NHTSA both have the similar reporting requirements for safety defects and recalls, but the difference at NHTSA is that a retailer is not subject to reporting. They are subject to the stop sale of a recalled product, but there is no obligation under NHTSA law for a retailer to initiate a report to NHTSA or to initiate a recall. It's just a requirement to obey a stop sale order that comes from a manufacturer after a recall is announced. But again, your goal would be to stay out of this world and to stay on the CPSC side and not try to get into selling motor vehicles, because there's a whole additional layer of regulation for retailers of motor vehicles under state law, state dealer franchise laws. So just a summary here, what are the differences between the two agencies? Bicycles and electric bicycles are subject to one set of performance rules. They're in CPSC's volume of the Code of Federal Regulations, and they're subject to substantial product hazard and noncompliance reporting and possible safety recalls. And that reporting does apply to you. If you know that your vendor has reported already to CPSC, you don't have to file a duplicate report. But if the vendor has not done so and you become aware of problems that could be safety hazards, then CPSC expects you to file the report and, if necessary, conduct the recall. Motorcycles are subject to 9 separate federal motor vehicle safety standards. They're found in volume 49 of the Code of Federal Regulations. And as I mentioned a moment ago, if you're selling a motorcycle, you have to be a licensed motor vehicle dealer under state law, which I expect most of you are not. I'm often asked about dirt bikes and other recreational off-road vehicles, and some of them can definitely go faster than 20 miles an hour. So where do they fit in the regulatory hierarchy? In general, NHTSA does not assert jurisdiction over any of these products because their jurisdiction by statute is limited to motor vehicles that are intended primarily for operation on public streets and roads. And dirt bikes are not. Off-road vehicles like the small 4-wheeled recreational vehicles, they are not intended for primarily for on-road use. NHTSA will generally agree with the manufacturer's designation that this is not intended to be operated on public roads. They're going to look for vehicle characteristics such as low pressure, knobby tires that are good for dirt and sand, but not good on paved roads. And they will look at the manufacturer's designation in its marketing materials, but it will not be enough for a manufacturer to just wave around the words off-road and avoid NHTSA jurisdiction. NHTSA, it will be especially concerned if the vehicle has lights and mirrors that you would need for on-road use, And if a state DMV is likely to license the vehicle for street use, NHTSA will claim jurisdiction. And if the product is for both on-road and off-road use, and it meets the speed threshold of 20 miles an hour, NHTSA will assert jurisdiction, and they won't stand down just because it's potentially suitable for use off-road too. If you think about it, a lot of motor vehicles like Jeeps and other four-wheel drive vehicles that compete with Jeeps are suitable for both on-road and off-road use, but they're definitely motor vehicles under NHTSA's jurisdiction. The fact that they can also operate off-road does not take them out of this coverage. I'm also often asked about the use of governors that a manufacturer might put on a bicycle to keep the maximum speed below 20. Software, for example, that kicks the power off when it senses that the pedaling has stopped. And in general, yes, that's permissible, and it will work to keep the product under CPSC jurisdiction, and NHTSA will respect it, but only if it's not easily accessible, removable, or defeated by an operator or by you at the retailer. If NHTSA finds out, if a manufacturer finds out that its speed governors are defeated in the market, NHTSA expects the manufacturer to redesign the governors that are less easily defeated or change to a strategy that does not depend on governors. So if the manufacturer posts a YouTube video showing customers how to bypass the governor, NHTSA is going to come down on that manufacturer, and they're going to treat the product as a motorcycle, and they will consider that to be a violation of the law. And if it should go without saying, but I'll say it anyway, if it has a switch that says sport mode or something like that, that just shifts it up to permitted operation above 20 miles an hour, but the consumer can select, that will make the vehicle a motorcycle, even if it's set to the lower speed when it's delivered to you or when you sell it to a consumer. If it has that switch on it, it's a motorcycle. If it allows a power only operation above 20 miles an hour, and that would be a violation of law for you to sell that without a certification of compliance to the motorcycle standards, which it's not going to have. That isn't going to happen. So I've mentioned penalties before. So what are they? At the Consumer Product Safety Commission, if you sell a bicycle or an electric bicycle that does not comply with the bicycle standard, the penalty is potentially $120,000 per bike, up to a maximum of $17.15 million for related violations. So if you sold 30 non-compliant bicycles, you would easily hit that maximum, and that would be considered related violations. This doesn't happen very often because Part 1512 is not hard to meet, and non-compliances with that standard are rare. The one place I've seen recent activity is in kids' bikes that don't have a coaster brake. There have been a couple of recent recalls for children's bicycles that are missing the required coaster brake, but that's the first time I've seen activity in Part 1512 compliance in many years. It's generally, for the adult size bikes, it's not difficult to meet the standard, and it would be very unusual for a product to be delivered to you that doesn't comply. On the other hand, NHTSA rules, violating a NHTSA standard or selling a motorcycle that does not comply with those 9 standards would be subject to a per motorcycle penalty of $24,423. So lower on a per product basis, but a much higher maximum penalty of little over $122 million for related violations. The reason these numbers are odd and CPSCs are nice and round is that NHTSA has to adjust its penalties for inflation every year, and they have to round it to the nearest dollar. So you can just think of it as almost $25,000 per non-compliant motorcycle and around $122 million for related violations. Both agencies prohibit the sale of a recalled product, whether or not the recall is for a compliance issue or for a safety defect issue, and the same penalty levels as are printed here would apply. So sale of a recalled motorcycle would be $24,000 $100,423, and sale of a non-compliant bicycle could be $120,000. These are maximums. Both agencies can compromise to a lower level and often do, but these are the penalties that would face a company that is selling a non-compliant or a recalled product. And I'm going to stop there, and let's open it up for discussions and see what questions. This is for you, and we want to be sure that we're covering what is of greatest interest to you. So Rochelle, you're going to moderate this?
Yes, thank you. We have a couple that came in already, so we'll just go ahead and start if you're ready.
I am ready.
Perfect. The first one is, if I understand correctly, adult bicycles don't have to be tested by an independent facility to meet CPSC standards?
That is correct. The manufacturer of an adult bicycle is permitted by law to self-certify compliance. I am aware that many manufacturers will use an outside lab just for confidence or because their retail partners want them to. And that is something that you can talk to your vendors about your expectations in that regard. But the law does not require independent lab certification. It does do so for children's bicycles, however. They have to use an independent CPSC approved lab.
Does the CPSC list on its website recalled bicycles and/or bicycle products?
Yes, it does. And you can search by manufacturer name, and then that will take it. I'll warn you, it's a clunky website. It's not really user friendly, but it is all there, and you can get recalls back 20, 30 years are on there, and it is searchable by manufacturer name. I've had CPSC staff tell me that they find the website so clunky that they usually just Google it and get into their own website through Google, which is kind of astonishing, but that's how clunky it is. But you can find it, and I will say that they just recently added an improvement to the recall portion of the website that is a little easier to locate. If you just put in bicycles, you're going to get a lot of junk, but if you put in a particular manufacturer name, it's going to be a little bit smoother. But if you just want to look at what bikes and bike products have been recalled, you can get there from the CPSC website, which is cpsc.gov, G-O-V, and it has a recalls tab on it.
Thank you. Are bicycle retailers allowed to service the motorcycle level e-bike mechanical parts?
Motorcycle e-bike is confusing me because those are two different things. Maybe I could ask the questioner to clarify. Did you mean, are retailers permitted to service, can we just say motorcycle parts?
Yeah.
Okay. There is no regulation of the service part of the motorcycle sector. That is, NHTSA does not prevent anybody from offering the services of repairing a motorcycle. You could open your own shop tomorrow and call it Motorcycle Services Inc., and you would be free to perform that service. Once you enter that sector of repairing motor vehicle equipment, you should be aware that there is a statutory prohibition on making any regulated component on that motorcycle. The statute uses the term inoperative. That's kind of legal jargon, but I'll just say you can't take it out of compliance. So if you want to do the service on a motorcycle, you can. You don't need a license. At least at the federal level, it's possible you would need a license at the state level, but that would be state by state. But the federal government does not preclude you from offering that service. You just now have subjected yourself to this restriction on you can't knowingly take it out of compliance. So if your customer says, I want you to take out the headlamp and put in a blue light instead of the white light, you cannot legally do that because the white light is required by Federal Standard 108. But if they just are asking you to do a tune-up, or they're asking you to perform some function that would replace the brake hoses or something, there is no federal regulation that would preclude you from doing that.
Let's see. I understand some e-bike manufacturers currently selling their products online and via retailers can easily have their top end speeds manipulated by going into the settings menu and have the speed set higher than 20 miles per hour. Do you see that as an issue?
Yes, that's illegal. Assuming they're not certified to the motorcycle standard, and I assume they're not. I assume they're certified, if anything, to 1512, and that is very definitely considered the type of manipulation of the speed that NHTSA would not respect. So therefore, NHTSA would treat it as a motorcycle subject to all of those motorcycle standards, and they would consider that e-retailer to be in violation of the NHTSA statute.
What is the age that is considered children's bikes?
That's a very good question, because it is not, it has, the answer has changed over time. Today, a children's product is defined by law to be a product intended primarily for use by a child age 12 or younger. When 1512 was first adopted back in 1974, CPSC considered it a children's product to be age 18 or younger, which is why Part 1512 applies to all adult bikes, because they reached the conclusion that a 15 or 16-year-old boy could ride the same product as an adult, and therefore subjected all bicycles to Part 1512. When the law was amended in 2008 to define children's product to be 12 and under, and the CPSC had to figure out how to deal with that new wrinkle, because we all know that full-size bikes are not suitable for most children 12 and under, they came up with a distinction on the wheel size. And they said, in general, we will assume that if the wheel size is 24 inches or smaller, that it's a children's bike. But that's a rebuttable presumption. We all know there's some BMXs out there with tiny little front wheels, and they're not children's bikes. And CPSC accepts that. But it's, in general, the presumption is if it's 24-inch front wheel or smaller, it is a children's bike that needs the independent lab certification. But that's not written, that's only in guidance, that's not in a regulation. It was guidance that was issued about the time that the 2008 statute amendment was changed, and that was a clarification sought by the Bicycle Manufacturers Association at the time.
The 20 mile per hour limit, is that based on zero grade and zero wind speed?
It's based on zero grade. Wind speed is not part of the definition. But paved, the term level surface is in the definition, which I interpret to be zero grade. And the weight of the rider is, the 170-pound rider is specified to take that variability out of the equation. Wind speed is not identified, but it's my understanding that if NHTSA were evaluating a product for whether it can exceed 20 miles an hour, that it would try to do it at temperate conditions so that they would not be, they would not want wind speed to be high, because that would potentially slow it down. They're going to want it to be zero wind speed or as close to zero as they could get it at the test track, so that they're trying to get a, they're trying to really evaluate the capability of that product. And this is not in the standard itself, but it's in a guidance document that NHTSA has issued. They would actually do 2 test runs and average the 2. So if there's a little bit of variability, if one slightly goes over 20, but the other one is comfortably within, that's not going to fail the I shouldn't say fail the test. It's not a pass-fail test. It's just it's a trigger, and it will not consider to have been triggered if the average is below 20.
If a company is based and located in another country and sells direct to consumer, can it avoid penalties and fines from the CPSC? It seems US retailers are taking the risk selling bicycles more than the foreign manufacturers making the products.
That's a very good question and a very fair observation, with which I agree. Technically, the entity offering the product for sale, import into the United States, is the entity that's subject to these penalties. So it might be a US, in a conventional model where the product is made overseas, there would be a US entity that would import it through customs and then deliver it to you. And that entity would then be responsible to either CPSC or NHTSA, as the case may be. In the case of direct ship, the business model that has an offshore entity taking orders online and shipping directly to the consumer, where the consumer is technically the importer of record through customs, is definitely a regulatory gap right now. And it's one that both CPSC and NHTSA are aware of, although on the motor vehicle side, it's a lot harder to do that. It's easier to ship a knockdown bicycle in a box than it is to ship a knockdown motorcycle. And customs is much more likely to stop that motorcycle that's coming in the country just because it's bigger and they're more on the lookout for it. They're not likely to stop an individual bicycle addressed to a home, to a residence of a consumer. So CPSC is well aware of that, and they're working with customs to try to find ways to be more capable of intercepting those imports and checking for compliance. That's a well-known gap, and there's a great desire to try to fill that gap. That's in part what motivated their litigation against Amazon, was that all three of the products being sold via Amazon, I forget the name of it, but it's a platform that where they don't take ownership. It's fulfilled by Amazon, that's the name of it. That they did originate offshore, and I think all of them were from China, and they were fulfilled by Amazon, but never owned by Amazon. Was not an intermediate owner of that product or a distributor, they claimed. But as I mentioned, the administrative law judge ruled against them and said they were a distributor under the CPSC law, and therefore they would have to do the recall. But that's one example of CPSC looking for ways to reach a responsible party who is handling a product that is manufactured in a foreign country. Unfortunately, though, they have to find somebody here in the United States. And that means it may be falling on many of you in the audience here, that the foreign manufacturer stays out of the United States, doesn't have any entity here over which either CPSC or NHTSA can assert jurisdiction. So you've identified a gap, and the regulators are aware of it, but their ability to close that gap is limited.
If one were to have a class 2 bike that simply had its throttle connector disconnected, would that make it a class 1 bike, even though the sticker on the frame of the product classifies it as a class 2?
The difference between class 1 and class 2 does not have regulatory significance at either NHTSA or CPSC, as they have not adopted that hierarchy. It will have a distinction for when and whether it can be operated on National Park Service lands or other federal lands once that class system is incorporated into the National Park Service and Interior Department regulations. And whether simple disconnection is going to be considered enough by those agencies, I think remains to be seen when that guidance is implemented. But it doesn't make any difference for NHTSA or CPSC. And put specifically, it's still probably an electric bike under CPSC jurisdiction, but it's definitely a bicycle, whether it's considered electric or not. And if the throttle is disconnected permanently, it's not going to be capable of going more than, it's not going to cross into that class 3 or into the motorcycle category. But if it's disconnected and just kind of hanging there and easily reconnected, then NHTSA would look to see whether when it's connected, it can go faster than the 20-mile-an-hour threshold with that throttle in operation. And they would not agree that just disconnecting it is enough to save it from the motorcycle category.
I believe this was right after the question about the age limit for children's versus adult bikes. Is there a difference between regular bikes and e-bikes for that age limit? And then are there any different standards for children's e-bikes?
There's no difference that CPSC has articulated, and therefore they would continue to apply the guidance of 24 inches unless that can be rebutted by other evidence that it's really an adult bike. And no, there are no there are no additional standards beyond Part 1512. So whether it's has a battery power or not, the lab would evaluate it under Part 1512 and give the independent lab certification of compliance.
If a bicycle is a pedal assist and can reach speeds of 20 miles per hour or more, is it considered a motorcycle?
If the pedal assist is structured that the motor will kick out when the pedaling stops, and that's not a selectable feature by the rider. It is automatically built into the interaction between the gears that the pedals are engaging and the motor, then and therefore it cannot go more than 20 or faster with the motor alone. NHTSA will respect that, and there is no it will remain an electric bicycle. If the motor continues at 20 or faster without pedal input, then it's a motorcycle.
People for Bikes and model state legislation specifically include language that prohibits the use of a throttle on a Class 3 e-bike, even if the throttle is governed to 20 miles per hour. It appears that CPSC allows a throttle on an e-bike that exceeds 20 miles per hour, as long as the throttle is governed to the 20 miles per hour. Since CPSC allows a 28 mile per hour bike with a governed throttle, what are the risks of carrying these bikes, even if state law does not allow it?
I can answer that under the federal law, not under state laws, because they're going to be different from state to state. But under federal law, I want to be sure I understand the question. The throttle is governed to stop at 20, except when the pedal assist is present. So it does meet the 1512 definition of an e-bike. There is no federal risk to carrying that bike, and assuming that it's a bicycle, therefore subject to 1512 and certified as such, as long as that governor is not easily defeated. If it's easily defeated, or if there's encouragement through the manufacturer's website or elsewhere to override that 20 mile an hour limit, then the risk is that you're selling a motorcycle and you'd be subject to the NHTSA penalties for doing so.
We see e-bikes being advertised with higher speeds than the 20 mile per hour and bigger motors than 750 watts. This appears to violate the law, but is there any enforcement, and is there anything that the industry should do to address it?
Very good question. I've seen those as well, and I've had discussions with NHTSA Enforcement Council. They're well aware of it, and they are evaluating what the best way is to approach that. But I want to divide your question into two subsets, because I think there are different answers to them. What you raised, one, you've seen motors that are more powerful than 750 watts. I've seen those too. I've definitely seen them. And that you've seen some that advertise speeds higher than 20. I've seen some of those as well. But the caveat for both of those is that even if you have a faster engine or a more powerful engine than 750 watts, that doesn't make it illegal by itself. It's the question comes back to the 20 mile an hour threshold. And if let's say you have a 2 horsepower engine, just will double that, and you want to offer that because it makes cool noise when it's riding, but it still stops at 20 when the pedal input stops. That's not illegal, and it's not a motorcycle. It's still a bicycle. It's no longer eligible for the safe harbor definition because it has more than 750 watts. But NHTSA won't take jurisdiction if it still stops at 20. If the motor power stops at 20 under the conditions spelled out in the law, it just is no longer eligible for the e-bike definition in the law. So that makes it a bicycle. It's not an electric bike anymore, but it would still be subject to 1512. It meets the definition of a conventional bicycle. And then the power would be a factor in evaluating whether it has shifted into NHTSA jurisdiction. So the size of the motor is, it's not illegal to have a more powerful motor as long as it still stops at at 20 when the motor is operating by itself. In terms of the higher speed, that is not illegal if it is limited to pedal input. That is, if the pedal assist is, and it really, we should call it motor assist, because it's the pedal is the primary function of input for the motive power of the product, and it's being assisted by the motor. As long as that is correctly designed to operate only with pedal input, the faster speeds are not by themselves illegal. But I know what you're talking about. I have seen websites that advertise sport, they have different words for it, sport mode or hyper cool mode, and they use kind of words like that. And it's pretty clear to me that they're going on motor power faster than 20. NHTSA is well aware of those as well and is evaluating enforcement options. It is complicated when they are on websites with no brick and mortar presence in the US, as we talked a couple of questions ago. And that's part of what I think is confounding NHTSA. But I have seen at least one brand name that does have a US presence that appears to be flirting with products in this space.
For retailers who offer e-bike rentals, are there any regulations that they should be aware of?
That's a very good question, and one that I will have to punt to state and local law. There is no federal regulation of rental that's different from offering for sale. So in the NHTSA world, putting a product into interstate commerce would include rental and would require the same attention to compliance. So if you're offering an e-bike for rental that can go faster than 20 without pedal input, you are putting a motorcycle into interstate commerce and you're violating the law if it's not certified to the motorcycle standards. But that is not a special rule for leasing or renting. That just comes with the territory of NHTSA jurisdiction. If it's on the CPSC side, if it is properly classified a bicycle and you're putting it into leasing or rideshare operations, there is no federal regulation that covers that. That would be regulated at the state and local level. And there's, particularly in urban areas, there's extensive regulation of those products, including maximum speeds and a lot of regulation about how they can be rented, what kind of, in some cities require that you have distribution across the city so they're not concentrated in affluent areas. Some others regulate whether they can be operated, whether they have to have a label about not being operated on the sidewalk, but every state, every locality is different. I've had reason to look at the rules in several jurisdictions, and there's some commonality, but there are also great differences. So if this is something of interest to any of you, you want to be sure to understand, and assuming it's properly classified as a bicycle, you're going to want to look at the local ordinances. In some jurisdictions, you have to apply for permission to be in a rideshare program. I don't think that applies to consumer level leasing if you're doing it through your retail shop to a consumer and not in a rideshare. But again, you have to check state and local law for what might govern that operation.
How does a retailer obtain a specific product's federally recognized top speed without the human power? Can they go to NHTSA for that?
I'm not sure I understand the question. Is it, how do you know as a retailer whether your product is compliant?
I believe that's the question.
Yeah, and then the answer is that your vendor should be providing you with evidence of certification to Part 1512. The law requires that to come all the way to the retailer, and it can be in the form that CPSC has a very specific certificate form, but it can be electronic. That is, they don't have to give you paper certification, but you have the right as the retailer to see the document that your vendor has produced. It has to accompany every shipment, or at least a quick link to it, or a website link to it is supposed to accompany every shipment that allows you to see the certification. They're not required to separately test every lot. It can be done on a batch basis, or most manufacturers will have a recurring cycle of surveillance testing, but that will be between you and your vendor to understand. And many vendors have their own requirements. Some vendors require, I'm sorry, some retailers require a third-party lab even for adult-sized products. That's between you and your supplier. But the evidence of compliance with 1512 should be in the form of a certificate of compliance that meets CPSC's certificate requirements. And it's somewhat different for the children's products, but again, they have to have the certificate of compliance that is issued by an independent lab. The adult products can be issued by the manufacturer itself. And that should be coming with every shipment that you receive. There should be evidence of compliance. If it's a motorcycle, the evidence is in the form of a certificate of compliance that's actually permanently fixed to the motorcycle that says this certificate certifies compliance to all applicable federal motor vehicle safety standards for motorcycles. I doubt you're getting any of those products because you're not registered. Most of you, or if not all of you, are not motor vehicle dealers under state franchise laws. So you'll probably never see that product, but you should be seeing certification to Part 1512.
I believe you just covered the answer to this question, but I'm going to ask it just in case. So
Sure.
Does the CPSC make companies put a label on the bicycle that says that it meets CPSC regulations?
No, the certificate accompanies the shipment, but does not have to appear on the bicycle itself.
Thank you. Can you speak to retailer liability for those who may install a battery and a motor to a conventional bike, especially converting a conventional bike into an e-bike that may exceed the manufacturer's original design of the bike?
Yes, that's a good question. Thank you. If a retailer adds a motor to a conventional pedal bicycle, then the retailer has become a manufacturer of that bicycle and puts itself in the shoes of 1512 certification, which means if the motor takes it above 20 on level ground, the other conditions that we talked about, the retailer has just turned that bicycle into a motorcycle. And since it won't meet the motorcycle standards, I would presume, the retailer has just violated NHTSA law by doing that.
Are there any notable differences in the rules for e-scooters without pedals?
Yes, thank you for asking. That's an interesting question and raises a number of issues, including a regulatory gap that I'll identify here in a moment. E-scooters are typically limited by their manufacturer to stay below 20 miles an hour so that they avoid tripping into NHTSA jurisdiction. And that's a choice that, to my knowledge, all of the e-scooters in the market today have up until now respected that 20-mile-an-hour limit and don't go faster than that. In addition, there are state and local rules that typically limit e-scooters to about 15 miles an hour. That would not be federal law, but that would be it would be illegal for a consumer to operate faster than that on an e-scooter in most, certainly urban areas in this country. However, there is a regulatory gap, and it is in the area of stand-up scooters that can go faster than 20 miles an hour. I'm going to, I think I can scroll back in my slides. I want to highlight again the definition in NHTSA law, which is more than 50 years old, is a motor vehicle with motive power having a seat or saddle for the use of the rider. Stand-up scooters don't have seats or saddles, and therefore they are they fall outside that definition of motorcycle. And NHTSA doesn't have any other category of motor vehicle for them to fit in. They have, when they wrote this rule, they thought they were covering everything in the market. So they have motorcycles, they have passenger cars, they have multi-purpose passenger vehicles like SUVs, they have trucks, they have trailers. They thought they covered everything. And then this sector just emerging in the last few years of stand-up scooters that may be able to go faster than 20. And I'm aware of at least one in the market that does. There may be more than one. NHTSA is all over this and intends at some point to amend the regulation to include stand-up scooters, I don't know whether they'll call it motorcycle or whether they will create a new vehicle type for it. But like most agencies, they can't do that quickly. Rulemaking takes time, requires public notice and comment. So my best guess, and this is just a prediction, this is not based on any information I've heard from the agencies. My guess is that CPSC will attempt to regulate it first, and possibly through the mechanism of saying they're just inherently dangerous and ban them, and then cede jurisdiction to NHTSA when NHTSA gets around to writing rules. But that is just a hunch. I don't have any inside information from either agency that that's in the near term going to happen. I think the greater leverage on the speed of e-scooters will be, for the time being, will be the state and local limits on operating them on streets and sidewalks. But the federal government is well aware of this. I have spoken to NHTSA about the stand-up scooter issue, and they are very much aware that they need to do something to address that space, either partnering initially with CPSC or attempting something by themselves. That there's, it's not hard to envision the safety hazards of sharing a freeway with a stand-up scooter. That's just not something the safety regulators are going to tolerate.
Is it possible that anything that a bicycle shop can do to an electric bike while it's in for repair, can anything that they do take it out of compliance?
Yes, and again, this would be, it would have to be a knowing, in order for this to violate federal law, and specifically the NHTSA law, it would have to be a knowing act, for example, to disable the governor and allow it to operate at 30 miles an hour, 28 miles an hour on the power only. That would be a violation of the NHTSA law because it would be converting the bike to a motorcycle. If it's unintended and not discovered, let's say they're making a correction to a brake cable and inadvertently do something that causes the pedal input connection to be broken, so that the motor now no longer recognizes the need to stop when pedal input stops, but it was completely unintentional on the part of the bike store and was not detected until the bike is back in consumer hands. That's not a violation of law to have done that unintentionally, but it would be a violation of law to do it on purpose.
In the case where somebody purchases an e-bike from a private party and then resells it, whose responsibility is it to ensure compliance to the CPSC?
Both CPSC and NHTSA have very limited jurisdiction over used products, whether they're used motor vehicles or used bicycles. They are not required to be recertified to comply. That certification obligation ends when the manufacturer delivers the bicycle to you retailers, or when the motor vehicle manufacturer delivers the bike to the motorcycle dealer and in turn delivers that to consumers. That's the point. And when you deliver a bicycle to a consumer, that's the last point at which compliance has to be certified. And that's for good and practical reasons. Products that are used might have worn out a little bit and might not be able to meet all of the performance standards that apply to a new product. So the regulation of the sale of used products is very limited. The one flag I would raise, and it's only on the CPSC side right now, is you cannot sell a used bike that's subject to an open recall unless it gets fixed. In the case of NHTSA, that applies only to new motorcycles. I think the law is going to be changed one of these days to apply it to used products, but right now it's not. But on the CPSC side, it is. So it's illegal for anyone to sell new or used bike that's subject to an open recall.
Okay. Does the UL 2849 standard certify CPSC compliance on e-bikes, or is that a separate evaluation?
That's a separate evaluation.
Does any of this information apply to aftermarket kits that are installed by a shop or end user?
Yes, it's the same answer that applied to a couple questions ago when the questioner asked about a retail shop putting a motor on a conventional pedal bicycle. It would be the same issue. If the aftermarket product attempts to convert it to an e-bike, it has to meet the e-bike limits, and it must remain limited to 20 miles an hour motor operation, or under 20. And it could not legally install a motor with faster speed capabilities without violating the NHTSA law. Other forms of accessories are not generally regulated, where the retailer's obligation would be derived from the general responsibility to avoid introducing a defect. So if there's a decorative product that goes on the spokes of the wheel of the tire and cause it to make noise to be cool, and that product interferes with the proper operation of that wheel and causes the wheel to freeze in riding, that retailer installed accessory would be a defective product and would have to be recalled. I'm trying to think of an extreme example to illustrate the point. But if the question is just generally, is there regulation of aftermarket accessories? In general, no, as long as it doesn't take it out of compliance with either of the two agencies' regulatory schemes and doesn't introduce a safety defect, there is no regulation.
Thank you. That appears to be all the questions that we have today.
And
So
we're coming in at an hour, so we can give folks back a little bit of their day.
there we go. So if anybody has any questions that's watching the recording of this, feel free to reach out to info@nbda.com and we will get your questions answered for you. Erika, if anybody wanted to ask questions of you, would they be able to contact you?
Yes, now with the caveat that I am not your lawyer, and that if we need to talk about giving legal advice, we'd have to form an attorney-client relationship. Today was just meant to be educational, and I hope it was helpful, but we don't have an attorney-client relationship with most of you in the audience. I may have one with some of you, but that would be formed individually. And if it looked appropriate, I'd be happy to work with you individually on any of the legal questions that you have. In the meantime, I intend to send Heather and Rochelle this slide deck, which I've authorized them to send out, and my contact information is on the first slide. Now, thank you for those great questions. I really enjoyed answering them and working to stay ahead of you guys. And if there are questions that come up after you see this slide deck and you want to reach out to me, we'll take it from there.
Thank you so much, Erika. And I saw the question, the recording of the meeting will be in the NBDA YouTube accessible library, so you can access the meeting there. And Erika, again, thank you so much for volunteering your time to educate retailers and come on today. Really appreciate you.
Thank you for the invitation and the excellent attendance.
Excellent. Thank you, everyone. Go have a great rest of your afternoon, and we'll be back here soon.
Bye.
Bye.